Hello, and welcome to the presentation for Group 49 for Corporations Law. The aim of this presentation is to explain the questions based on the case study regarding the duties of a company director and the employees as per the Corporations Act 2001. There are three major questions to be answered in this presentation. Each question relates to the topic at hand and will be presented by the specific team members. The case begins with James Burton, who is considering buying shares in a company called Saturday Night Live Limited. After purchasing 1,000 shares of Saturday Night Live Limited, James received an email from the company secretary advising him of the forthcoming annual general meeting. As a new shareholder of SNL Limited, James has plenty of questions to SNL's company secretary and other employee members.
Hi, my name is Sunny Singh. I'm from Group049 and I'll be answering question number 1 from the group assignment. In question number 1, James has some concerns over the term members and shareholders and how and the ways in which a person can become a member. So members and shareholders, both the terms are used to denote ownership of the company. In Australia, a member of the company is referred as shareholder. This means that the two terms are synonym to each other and can be used similarly. Let us make a reference to Corporation Act 2001 to understand what member means. Section 9 covers two criteria of member, that is, with regards to management investment scheme, and the one regarding companies as is set out under Section 231. Now, let us address how to become a member. A person can become a member in different way by following Section 231 of the Corporation Act. This include be named as a member when company is registered. For this, written consent is required before application for registration as an Australian company is to be made, covering name and addresses of the individuals seeking to be a member to the ASIC. Second, agreeing to be the company member of an already ASIC registered company. Again, the consent covered in previous part is required so that the person can be added in register of members. Third, when a person is already a member of a company that was limited by guarantee and had changed into a company limited by shares. Now, let's move to eligibility to become a member. In order to become a member of the company, the applicant must be a person or a body corporate or a body politics. Examples include John Snow, like King's Landing Private Limited, or State of Stark, respectively. An entity that can sue or be sued on all property is eligible to be a company member. When it comes to trusts or states, they can become member through their nominated trustee or executor, respectively. There is no age limit to become a member, though companies can use this per discretion. Now, let us move to the next query regarding required number of members. There is a minimum requirement of having one member in a company. In case of proprietary companies, the upper limit is 50, and to the public and for public companies, there is no such limit. Thank you.
Hello everyone, my name is Ashna from Group 049 Corporation Law. Following in the presentation, I'll be answering the second question in the group assignment. This question concerns James receiving a notice from SNL Limited. The annual general meeting would start at 1 p.m., but due to traffic, the meeting chairperson was delayed and the meeting started at 1:10 p.m. instead. James raised a question regarding this delay and inferred that it could cause a procedural irregularity and the entire general meeting must be conducted once again. A procedural irregularity can be defined as the absence of quorum at the general meeting, a defect, irregularity, or a deficiency of notice. In this case, it is the annual general meeting of SNL Limited, but it is necessary to do so. As per the Corporation Act 2001, the annual general meeting states a proceeding is not valid due to any procedural irregularity unless the mentioned otherwise by the Code Section 1322 subsection 1. The chairperson's delay is not considered a procedural irregularity. Section 1322 subsection 2 states that the absence of quorum and a defeat of notice or time will make the outcome of the meeting invalid. Hence, I can advise James that the members can elect another member to the chair the meeting only. Another alternative for this is to use teleconference like Skype, Zoom, and there are many more. Considering all the above points, James can be advised that there is no need for annual general meeting to be held again.
Hello, my name is Swapnil and I will be presenting the possible answers to question number 3. The most appropriate method to answer this question is using the IRAC method, which is the issue, rule, application, and conclusion method. Before we begin, let us try and understand the case question. Alan is the Chief Financial Officer for Saturday Night Live Limited. He has become aware that the company is seeking a tender for some major renovation work to its offices. Coincidentally, Alan's cousin is also in the renovation business, and Alan tells him of the tender sought by SNL, along with the price details that has been discussed in the company meetings. Alan and his cousin attend the meeting for the contract, but Alan does not disclose his relationship with his cousin during or before the meeting. Apparently, after the meeting, Alan's cousin wins the contract for renovation at Saturday Night Live Limited. The major issues to be examined in this case are: first, has Alan breached the duties of a company officer? And second, can there be criminal charges against Alan? The first term to understand here is a fiduciary. A fiduciary is a person in the company who performs their duty with utmost good faith and honesty, keeping terms with the rules and regulations of the business legislations. This generally adheres to the managing officers of a company. As per the Corporations Act 2001, a director or an employee must obey the following rules. Section 180, Care and diligence of the company duties. Section 181, Perform all duties with utmost good faith. Section 182, Must not make wrong use of their position in the company. Section 183, Must not make any wrong use of the confidential information of the company. Section 184 deals with the criminal offenses for violation of the above. And Section 191, the company officers or the director must not have any personal material interest in the company affairs. It is very clear that Alan has violated Sections 182, 183, 184 and Section 191 of the Corporations Act 2001 by divulging the company information to his cousin regarding the contract. This could lead to serious legal actions. for his criminal offense of disclosing the company's confidential information to his relative, in this case his cousin, and this is with reference to ASIC versus Adler 2002. This means a penalty of $200,000 or 5 years imprisonment, or maybe both. We can also contemplate that Allen could have done it entirely out of ignorance or without any personal interest. Unfortunately, this cannot be proved, and the least Allen could have done is revealed his relation before the meeting and inform regarding the non-intent of any personal interest. Since that did not happen, it is Allen's duty at least to inform the board about the situation at the earliest, and the director or the board could maybe forgive him for the act. On behalf of Group 49, I thank you for listening to our presentation and welcome any questions that you may have.